Good morning. I would like to call the January 26, 2024 board meeting to order, and the time is 9:06. I would like for us all to rise and do the Pledge of Allegiance to the United States flag and the Texas flag. Sorry. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Honor the Texas flag. I pledge allegiance to thee, Texas, one state, under God, one and indivisible. Thank you. So good morning. I'll start the meeting this morning with the board's mission statement and philosophy. The mission statement of the Texas Board of Nursing is to protect and promote the welfare of the people of Texas by ensuring that each person holding a license as a nurse in the state of Texas is competent to practice safely. The board fulfills its mission through the regulation of the practice of nursing and the approval of nursing education programs. This mission, derived from the Nursing Practice Act, supersedes the interest of any individual, the nursing profession, or any special interest group. Our philosophy: acting in accordance with the high standards of ethics, accountability, efficiency, effectiveness, and openness, the Texas Board of Nursing approaches its mission with a deep sense of purpose and responsibility and affirms that the regulation of nursing is a public and private trust. The board assumes a proactive leadership role in regulating nursing practice and nursing education. The board serves as a catalyst for developing partnerships and promoting collaboration and addressing regulatory issues. The public and nursing community alike can be assured of a balanced and responsible approach to regulation. I'd like to welcome all board members, board staff, and audience this morning to this board meeting. This meeting is being held pursuant to Texas Government Code Section 551.127. Please remember to mute and turn off any cell phones. Today's meeting is being held in person at the Barbara Jordan Building located in 1601 Congress Avenue, room 2.035, Austin, Texas, and is open for anyone of the public to attend and observe. We'll begin with the board member roll call. Dr. Benton?
Kathy Boswell, representing AD in Education.
Kathy Boswell, present.
Daryl Chambers, representing Consumers.
Daryl Chambers, present.
Laura Disk, representing RN Practice.
Laura Disk, present.
Carol Hawkins Garcia, representing RN Practice.
Carol Hawkins Garcia, present.
Maisie Jamison, representing Consumers.
Maisie Jamison, present.
Ken Johnson, representing LV in Education.
Ken Johnson, present.
Kathy Lederhorn, representing LV in Practice.
Kathy Lederhorn, present.
Allison Porter Edwards, representing BSN Education.
Allison Porter Edwards, present.
Drew Riddle, representing APRN Practice.
Drew Riddle, present.
Melissa Scott, representing LV in Practice. Ms. Scott is absent. Kathy Shipp, representing APRN Practice.
Kathy Shipp, present.
Rick Williams, representing Consumers. Mr. Williams is absent. Kim Wright, representing LV in Practice.
Kim Wright, present.
Madam President, we have a quorum.
Thank you. At this time, we'll proceed with the introduction of board members and staff. Dr. Edwards.
Good morning. Allison Porter Edwards, representing Baccalaureate Education.
Good morning. Daryl Chambers, representing Consumers from Grand Prairie, Texas.
Good morning. I'm Laura Disk, representing RN Practice from McAllen, Texas.
Kim.
Kim Wright, representing LV in Practice from Corpus Christi.
Good morning. Ken Johnson, representing LV in Education, faculty at Howard College, San Angelo.
This is Maisie Jamison, representing Consumers from Dallas, Texas.
Good morning, this is Kathy Leader. I represent LV in Practice. I live in Granbury and practice in Fort Worth. And I do believe the North Texas Coalition is being well represented on this board now. There's so many of us.
Kathy Boswell, representing ADN Education. Carol Hawkins Garcia, representing RN Practice from San Antonio.
And Drew Riddle representing APR in Practice from Fort Worth.
And Kathy Ship, representing APR in Practice from Lubbock. Okay, thank you. We'll start with staff.
Good morning, I'm Kristen Benton, Executive Director.
Good morning. My name is Dusty Johnston, General Counsel with the board.
Good morning. My name is Anthony Diggs, Director of Enforcement.
Elise McDermott, Director of Nursing.
Good morning, Hemant Macon, Director of Operations.
Jan Hooper, Lead Education Consultant.
Beverly Skloss, Nursing Consultant for Education.
John Vanderford, Deputy General Counsel.
Patricia Villanes Cabrera, Executive Assistant.
Paul Bradley, Lead Consultant for Nursing Practice.
Timothy Sherman, Nursing Consultant for Advanced Practice.
Christine Riley, Nursing Consultant for Practice.
Jolene Zeig, Nurse Consultant for Advanced Practice.
Sarah Chaput, Nurse Consultant for Practice.
Yeah, good morning. Abhi Gimire, IT Manager.
Good morning. Bruce Holter, Information Specialist with Nursing.
Daryl Holt, IT.
Brian Evans, Admin Monitor, Live Stream Producer.
Thank you, board members and staff. So, we are continuing our agenda from yesterday. We have 3 items that we will be taking care of today that were not completed yesterday and were on schedule for today. So the first one is, 1.2.1, update of pending litigation in the matters of, so this is pending litigation, and our attorneys will be helping with this. Mr. Johnston?
Thank you, board members. This agenda item is generally put on consent. It's an information item only. It always, the purpose of it is to sort of inform the board of what type of pending litigation is out there that names the Board of Nursing as a party. As y'all are aware, the administrative staff, the lawyers here, do a lot of contested case work before the State Office of Administrative Hearings. The litigation there is known as contested case. It's under the Administrative Procedures Act. Those matters can be performed by staff of the agency or by the Office of Attorney General, because the Attorney General's office by Constitution is authorized to represent the state in litigation matters. Well, they reserve representation of the state in district court, state court matters, the district courts, the appellate courts, the Supreme Court. So what you'll see often when the Board of Nursing is named in a lawsuit, the Attorney General's office takes over, or more or less, we're their client. And those matters will get filed in district court, and then they'll proceed, if necessary, to an appellate court or the Supreme Court. Oftentimes, when a party is appealing something that happened at SOA, for example, that's a original petition in district court to challenge the board's order over their license. That is referred to the Attorney General's office, and then they will file an answer defending the board's decision. And most of our pending litigation is that type of proceeding. This agenda item sort of updates if anything changes. If not, it sort of reports the status quo often. It's kind of been put on consent because a lot doesn't change, right? The party appeals, the Attorney General comes in, they file an answer. It gets postponed. It's a lot of times it's up to the respondent in those types of matters to pursue their case, to challenge it. Oftentimes, they're under a board order. They need to work. They don't really go much further than that, and then it just sits on the docket, sometimes for years. And that's why you've seen a lot of these matters that are reported sit there for many years. There's other types of litigation. And I think that another reason why it's pulled off to kind of give the sort of the new board members kind of an overview of what this is. Dr. Benton was talking whenever she first came to the board and she saw this agenda item. It named the executive director by name as a defendant in a lawsuit, and it became kind of like a what's this all about? I mean, what's going on? Why are people that I know and I think are good people getting sued by people? And that's because in matters of litigation like this, whenever you want to challenge an official act of an agency, you do have to name a person in their official capacity. So oftentimes these lawsuits will contain the name of the board and the executive director. And potentially the president of the board and whoever they feel compelled they need to identify whenever they file a lawsuit. There's also embedded in this agenda item the required notice by law under the Open Meetings Act that if you want to entertain a settlement or talk about making a decision about how to settle a case like this, a lawsuit, then you need to tell the public that you may go into a closed meeting to talk about the lawsuit with your lawyer. And this agenda item sits here with the potential that any of these matters listed may present themselves with an opportunity to settle them. And if y'all wanted to talk about that settlement with your lawyer, then you could go into a closed meeting, and that would be not webcast on what your lawyer advice would give you and that type of deal. So you see that this agenda item always has this opportunity that the board can break into closed meeting. There's other items on here of note, I should say, that are not just nurses who are trying to challenge a board order against their license. We have the Board of Nursing as a plaintiff against Ken Paxton, Attorney General. Oh, what's that? Well, we're obligated under the Public Information Act to provide people with public information that we have whenever they make a request to us. There are items that can be withheld from a Public Information Act request. The way that's done is that if you want to, the agency wants to, they're obliged to ask the Office of Attorney General to provide an opinion on this request and why the agency believes that it can be withheld under the law. And then the Attorney General office will make a determination. We also have the right that if we're in disagreement with that determination, that we can ask that be appealed to a higher authority, the district court, for a ruling on whether or not the information that we want withheld and that the Attorney General's opinion has said probably should be can be determined by a judge. you have two matters here that relate to those types of appeals, where we ask the Attorney General, it's ironic, I don't know the word. You ask the Attorney General, because he's constitutionally authorized to represent you in district court, to represent you against another branch of his office who has determined that the public information should be disclosed. And so we have two divisions of the Attorney General's office that are sort of at each other, they're on opposite sides of these lawsuits. Now, I will say that this type of litigation is awkward. It doesn't really function probably as efficiently as you might think it does, but it is an opportunity for us to make our legal argument and for the Attorney General of the Open Records bent to say this should be public, and have maybe that a really unanswered legal question be determined by a judge, potentially in the board's favor. And so some of these are that type of matters. Most just sit there unresolved until someone forces movement. And because most of these are, while they're pending, the status quo remains the same, for us lawyers, we don't worry about it. Oh, it's out of sight, out of mind. We'll put this on the pending litigation update and put that on the consent agenda. So that but when there are questions raised, or if you do want to, or if a settlement comes our way, or oftentimes on this agenda item, or some of these matters settle or go away or dismissed by the court, and then you'll see that the pending litigation list changes, and we try to put those updates into the report so that you'll see that this lawsuit that's been sitting out there for 8 years finally got dismissed. And that's really the purpose of pulling this off consent. It wasn't designed to say, let's talk about all these particular lawsuits because they're handled, they're status quo, they're probably getting settled or just dismissed as we speak, the way lawyers do it, which is communicate every 3 to 6 months about it. And so that's kind of the end of my report, if there are any questions.
Any questions, comments?
I'd just say as a new board member, thank you. That was really helpful to understand sort of what we're seeing. I'm still wrapping my mind around the fact that we're the plaintiff in a lawsuit against the Attorney General's office, and the Attorney General's office is representing us as our, anyway, I get it. It's just seems odd to me, but.
It's been subject to a lot of criticism, I think, and we're the, yeah. We're kind of the weak link in all that, by the way. But we have some good, justifiable. One of the experts, a list of our experts, our consulting experts. We in litigation, sometimes you need a consulting expert that is confidential. There's a lot of confidentiality around getting information from a consulting expert to help you develop your case if you don't want to use them in litigation. Well, we use experts like that. We want to use experts like that. We can't be, it might have a chilling effect for us to be able to get experts that, we have to disclose, which happen, give us all your experts or whatever. And we're like, no, there's a rule of evidence. There's a rule of civil procedure that you don't have to disclose consulting experts. So that's one of the issues that's out there. The other one was, Oh. We had a matter that went through formal, up to and including formal charge stage, but then it gets closed, okay? A closed case is characterized as a confidential case by us. The complaint, the investigation, the material that's developed, all that is confidential. And if it's closed under our statute, that material, you have a right to have that material go away and never be disclosed. Well, we have another portion of our act that says when a formal charge is filed, you can share that with the public. But now it's closed. The formal charge isn't going, the case got closed. So the formal charge status, which was public at a time, we want to argue, no, that's part of a closed case, just like all of our closed cases are confidential. That is another question that I think would be good to answer. So because the individual who we presumed probable cause existed for this didn't, but somebody wants to know, about something that normally would never be disclosed. So those are interesting. They've been around since 2019 and unresolved. Although they're working out. They're working on it, I guess. Mm-hmm.
Could you describe the process for petition for judicial review? What is that process?
Okay. A petition for judicial review is the name that they call a lawsuit against an agency to challenge the decision that they made. It's just called a petition for judicial review because a judge is going to review that. It's a, plaintiff's original petition. You could call it a plaintiff's original petition if you wanted to. What is it? It's a petition for judicial review of the, agency's decision.
I had a question. Just out of curiosity, the case with the restraining order, that one just was so odd to me. That someone filed a restraining order against
us?
Kathy.
Well, okay.
That's so weird to me.
Let me talk generally about petitions for judicial review. Under the Administrative Procedures Act, if you're going to challenge a final order, a final appealable order of an agency, you can file a lawsuit in district court to challenge it. But that doesn't, in all lawsuits, in all sort of appeals of judgments, I should say, in all appeals of judgments, there's a concept known as it's final and appealable, meaning you can enforce it. Then there's a concept of, in district court, if you want to appeal it and you don't want it to be enforced against you, you can file a supersedious bond. You can do something that effectuates the status quo of not being able to be enforced while you appeal. The same kind of concept exists in administrative law. You have a board order that's requiring you to do whatever, maybe it revokes your license, maybe it requires you to not work unless you're under supervision. If you appeal that to district court and file a petition for judicial review, you're still subject to the terms of that order unless you do something to stop its effect. Okay? And a word for that, if you're going to stop the effect, if you're going to try to effectuate something against someone to make them do something or to stop them from doing something, that's called an injunction. You're seeking an injunction to enjoin them, to stop them from, what we would say in that situation is to stop them from enforcing that order. So it wouldn't be unusual for a respondent who's appealing an order to also want to ask that the order be enjoined. And, that you would ask the officials that are in charge of enforcing that order to not do it. So you would enjoin the party from enforcing the order.
I have a follow-up question.
Mhm.
So if they file for that injunction for it not to be enforced, and say, hypothetical, the license was suspended because of endangerment to a patient. So now this person can continue to practice until a judge looks at that?
Nope, they have to have it heard. That's just the vehicle for asking for it. They're asking for the injunction.
Okay.
You have to have a hearing, and there has to be a court saying no.
Okay.
In that particular situation.
They don't just pass, it's automatic.
Nope. Not anyone, nope.
So while it's sitting and waiting, they
Still have to
sometimes
comply with the
and
order.
maybe by the time it comes up, they've already completed the order.
It may be that that's true for some of these, that has just, no one's really gotten around to it yet. But that's one thing about filing a lawsuit. Unless you get an order out of it, it just sits there. John?
That was an excellent board report, Dusty.
I knew you'd like it. Hope I didn't miss anything.
So I was just going to ask one thing, just coming from the president, and I don't know if that's a Patricia question or a Dusty question, but in times past, changes were highlighted in yellow. So I'd kind of read, but then I'd go, okay, that's what's happening, and this one has no color in it. I don't know who.
John?
I don't know who that question goes to.
I mean, we can make that happen for you.
Okay,
President Shipp, I'm colorblind, so it doesn't show up for me the same way that it shows up for you. But if you'd like, we're happy to add more color to the board report to highlight the changes.
I think we missed Gina.
Yeah.
was that what it was? And I just want to say that we try to peruse and look over all of the data that's in front of us. And that would be reams of paper if it was being printed. So I look over and I kind of see, okay, this one's been here for a while. And so I kind of scrolled down and saw that. So this time I was like, oh.
Yeah, where's the yellow? Yeah.
And it was just a bullet, just kind of like, okay, this is the most up to date because I have looked at it before. So thank you for that. Didn't know that was the answer.
Happy to be of service.
Great. I love these guys. They're our heroes, for sure. Thank you. Okay, this was just an information, so there's no voting. So we're going to move on to 1.3, Texas Board of Nursing Fiscal Year 2023 Annual Report. Dr. Ben.
Can I just say, this is one of the benefits of meeting 2 days. By Friday, we're all a little delirious and all of our guards are let down. But anyway, okay, so what you have before you is our fiscal year annual report that summarizes kind of the big picture agency statistics for fiscal year 23, which, as you know, that ended on August 31st. A lot of the trends are continued from the previous fiscal years. There are a few items that, definitely cause, one to scratch your head and think about, gosh, what's going on? But as you can see, the RN population continues to grow steadily, and we are seeing for a third year in a row that the LVN population is decreasing slightly each year. APRNs are continuing to skyrocket, which really begs the question of, do we have the current capacity to continue that growing workload? All righty. Looking at revenue, you can see that we continue the trend of a surplus, and things are looking healthy in that regard. And then to discipline, those trends are similar. Very few licensees at any given point in time are sitting with a current disciplinary order, which, I like to interpret as nursing practice in Texas is strong. Okay. Then when we look at a breakdown of the types of complaints that result in discipline, those percentages remain steady also from year to year. You can see that over half of the complaints have something to do with concerns about fitness, drugs, alcohol, misappropriation, deception, fraud, et cetera. Only, under a quarter of the complaints are truly pure practice issues. Now, at the bottom of page 2, this is one that I think we all need to look at and think long and hard about. You can see that in last fiscal year, the percentage of cases closed within 6 months has dropped from 87.3% to 74.9%. Now, I will say, if you read through the text of the narrative about enforcement's dynamics, they've had more complaints. So they're getting more new complaints, but we do have a slowdown on closure of cases. So we will definitely be honing in on that as we look to strategic planning and looking at our workforce and what we can do to help tackle that issue. Proposals, this just gives you a 5-year trend of the types of education proposals and the numbers. Clearly, this year is a busy one, 4 yesterday. And then you have the pass rates for the NCLEX RN and the NCLEX PN. Again, Texas is really strong. Nursing education in Texas is doing a phenomenal job of preparing their graduates. We have, as far as I can recall, always been above the national average, which is really something to be proud of. This doesn't have, obviously, the 2023 pass rate because we didn't really have those numbers yet, but there's a tentative number in the narrative of the report that's very good. So that's kind of a summary. This is information only, not an action item, but be glad to answer any questions. And of course, we have the directors here to answer questions as well.
Can this information be disseminated?
That's a great question. Yes, this is something that we will use in the legislative session. We'll use in our strat planning. It will be posted under the publications and reports link on our website. And we're kind of gearing up for the spring conference season, and we make a concerted effort to summarize these numbers when we go talk to deans and directors, TAVNY, TNA, et cetera.
I think it's great because I have nurses come to me all the time. Did you see all those But it's such a small fraction. And we have a different perspective because we sit through E&D and that, those sort of things, but it is just a small fraction. My other question was, as far as investigation, cases being closed within 6 months, is each complaint a case? Or is it, you didn't invite me to lunch, so now I'm going to turn you into the board for not crossing a T on your charting, that sort of thing? Is that, because I'm sure that happens. And if so, is every complaint a case? Maybe that's the.
No, ma'am. It has to be a violation of the act. So if we receive a complaint and it says, you didn't invite me to lunch, that's not a violation of the act.
So you don't even consider that a case, but it's just delete.
Yes, ma'am.
Well, I remember, so I've been here 13 years. So it seems, and I remember when I'm a newbie, and I feel like a newbie sometimes, even in these meetings, on the information, but it was just took forever for you guys. I mean, it would be a year. It was well over 6 months, and it was a year and a half, and we were doing those new fingerprinting. And I mean, when we decided to fingerprint the whole, everybody, and all of that was happening, and then it was just so crazy. So, to me, I mean, this is so much, in all those years, it's been so much better. But do you just have some insight on this little difference here, even though it's not that much of a difference, but it looks like it on the graph?
Sure. That's a good question. The Board of Nursing was not immune from the effects of the pandemic. We lost staff, and we are still in the process of getting new staff on. Every time you lose somebody, you have to train new staff. During the pandemic, we were having issues getting people to apply or getting good candidates for the position. We lost 6 investigators, seasoned investigators, within a very short time period. Because of that, our performance measures declined. I'm sorry? Thank you. I kind of forgot where it was, but we are currently in a good position where we've hired new staff, we're getting them trained, we've changed some of our processes. With the pandemic, we had to change a lot of our processes because everybody started working from home. We didn't have the luxury of everybody being in the office and having their resources available to them. We had to change everything. Everybody had to have a home office. So we're still dealing with the effects of that, but we're in a better place. Did that answer your question?
Yes, and I just wanted to state, we've come a long ways, too, from when I first came on, because I was like, why is it taking so long for so many cases? But, you had to bring them in. There was a lot you had to do. And I appreciate that, because to me, COVID's in my rearview mirror. Do not want to go there, but we still need to remember that. So, thank you.
And Madam President, if I'll add, I think this is a given, but I think it should be stated that, the time it takes to close an investigation is multifactorial. When you have a respondent who, seeks counsel, that, sorry, lawyers, that can really slow things down. So I'm not saying that accounts for all of the decrease, but I do think it's something to consider, because those investigators are working their tails off.
Mm-hmm. So what do you think that's just ballpark, when you bring a new investigator in? I understand some have some experience in that versus others. Do you think where they can be very independent? Is that 6 months? Is that a year?
Yes, ma'am, that's a good question. And it depends on their experience level, but in order to learn all of the processes, it takes anywhere from 6 months to a year for a person to be let go and autonomous.
Mm-hmm. Yeah, that's a lot.
Madam President, Drew has a question.
Oh, I'm sorry, didn't see.
Oh, that's okay. Thank you, ma'am. I recognize that a lot of the, at least in my mind, a lot of the ability to close the case within 6 months is honestly somewhat out of your control and your office's control if a respondent decides at the 5-month and 29-day mark to get outside counsel, et cetera. Is there a way that is tracked and maybe even peeled out of the data to show here's sort of the why? And I don't understand the appropriations process very well, even though I sat through 2 days of a fascinating conference on that. But is Is there a way to demonstrate manpower issue versus, this is sort of, we could have 1 million investigators all teed up, ready to go, and it's still going to take 1.5 years because of something completely out of your control. I don't know how the data is collected or if that's worth even looking at or if that's something the board even should consider, but it seems to me like there would be a metric, yeah, and there probably is, it just may not be in the report.
I'd say the historical metric is cases per investigator. Kind of is how is what you can. I mean, you go nationwide. It's all anecdotal, whatever you want to say. You know, people have lawyers, people don't. People, can't get evidence. In some cases, you can, in others. But then you'll have like the pandemic hits and people leave. All of a sudden, an investigator caseload goes from 150 to 225. Well, that's the metric. Same with the lawyers and the lawyer caseload. The higher your caseload, the slower it is sort of that's the metric that withstands the test of time, I think, from my experience. We have, for years, Texas is big, but its staff has always been small, I would say. And for years, we've, back in the day, this whole bit about what I'm fixing to present to y'all in a minute is sort of taking me through a memory lane. And I didn't realize I was that old, really, because I don't feel that way. No, really, I feel that way, too. But Tony and I used to be part of, even back then when we've done it so much longer now, but back then we'd go to National Council, we do these, Kathy got us involved in trying to do these seminars with the enforcement people, the investigator. We would do our presentation. We did presentations on everything, our matrix, our evaluations, our, the way we did things, we were rolling in the lead, I would say, in the vanguard of a lot of these things. Attribute that to Kathy Thomas and to Tony, really. And our investigators were always like 180, probably. I felt like that was the number I always kept hearing. And then somebody like, Washington or, Alabama, they're like 25, 50. You're like, what? Just incredibly low ratios. And because of that, I think because of that history, I don't even know what the good metric is. Because we've always been so many per investigator. What is the ideal? Because some of these other states are so far below in their caseloads, you don't know where the sweet spot is, really.
Could it be something where, because I think visually it might look better too if we could see at what stage maybe cases are at?
I think we have that metric too.
Yeah, I think I've seen that before in another report. That might give a better picture.
And I did want to add in, this is also Nightingale year.
Yes.
Mm-hmm.
I mean, that's like, I don't know how many of those cases are, we were at over 200.
But we have extra staff for that.
Yeah.
We've asked for extra staff for that. I mean, we're in the process of hiring new investigators, additional investigators for the Operation Nightingale issue. But we're still trying to hire the investigators that our current FTEs.
Not on yet. So we're still have that front loaded. I mean, when you add 200 and some cases.
But on the operation, and forgive my ignorance, they did it. It's done, closed. You bought your degree. How is that an investigation?
Because they're contesting.
Yeah.
You've got to be kidding.
Oh, yes.
Because they went to class on weekends.
I have a quick question. Tony, how many FTEs how many vacancies do you have in your department currently?
6. We have 4 investigator positions, 4 investigator positions, 2 monitoring positions, I believe 1 administrative technician position. And then we're asking for 2 Operation Nightingale positions.
And how many positions do you have in your department? Legal?
I have to look at the chart. At least 3 lawyers and a legal assistant. 4. Sounds right, doesn't it?
Mm-hmm. So, yeah.
2 potential Nightingale positions, and then 1 open lawyer position as it
And then
stands
a
now.
legal assistant
And then
position.
a legal assistant position.
And education?
By the way, we've been trying to fill those for, a long time. We've interviewed quite a few people. We've made
She doesn't have a microphone.
quite a few offers.
But those positions are budgeted for, right? And y'all do use contract labor?
We use contract labor in the sense that the Attorney General's office has agreed to work under contract with us and provide some of their staff time for Operation Nightingale.
We've also contracted with 2 education consultants, apart from the Education Nightingale position that's posted, to help with Nightingale.
That's thanks to Chris working on that. But we have 5 full-time education consultants for 235 programs now. And 2 of us have been working a good bit of our time on the Nightingale. And we're bringing in some other consultants to help us. But Chris has arranged for us we have already hired 2, and they're starting to learn the process.
I think one of the things that I think we need to always consider is the Attorney General is going to help us, but they don't just start it. You guys have to get it ready and have to have a lot of information for them to pick it up and run with it. And so it's not like you're just like, oh, that's 2 full-time people that just they hit the floor running after you.
And President Shipp, so even with the Attorney General's office, we still have to use all of our consultants to testify as the experts. So it's also taking them away from survey visits, things like that, to then also keep up with those cases. So yes, it's legal, prepping all of it, and then our consultants also testify.
I volunteered to testify. Let me at them. Yeah, I will be more than happy. I can be an expert witness.
That's also, so that's Operation Nightingale, and then we have our practice team that does regular practice cases, in which we have 2 open positions on that team as well.
Thank you. Well, I just want to say I love this report. This is so easy for us to look at. And I think it just showcases and how it's presented. So I know it's a group effort and it's really good.
Huge thank you to Bruce Holter, who makes it pretty.
I thought so.
And tolerates the 18 rounds of edits.
I thought
Yeah, it's a
this
really
looked like a
good-looking
Bruce
report.
product, as well as the bulletin. Yeah.
I have just one final question, Madam President. I'm sorry. Pardon my ignorance, is there anything that as a board we can do to help to assist the agency in, we can't go out and recruit and hire these people, but is there an action that the board you need from the board? I don't know if that's the right question to ask, but I feel like we're a body that maybe could help. I don't know what that would be, though.
Right. I think, and anyone can pipe in, I think at this point, just disseminating the information is really helpful. And stay tuned for the LAR, because that's when we'll need you.
Mm-hmm. Thank you. And you're starting on that in February, end of February, or the?
Yes, well, honestly, it's a never-ending process.
Okay, yes.
That's right, yeah. LAR is always on the mind, but officially, the instructions for strategic planning should drop at the end of February. The plan will be due around the beginning of June. As the strategic plan process ends, the LAR process begins. And last session, all agencies were given 29 days to do an LAR. So we're standing by to see how much time we have, but that will be pretty much June and July.
Madam President, my senator is very interested, and so he will want this report. So thank you for that.
That's great. Thank you, guys. This is such great work, staff, and I know not all the staff are here, but make sure they know, that you tell them that we're just raving about it and the work and how much. I would just, thank you. We appreciate it, and we know that there's been changes in positions and all, and you're hitting the floor running, and Dr. Benton as EO, good job, and thank you for that, and yes. Yes. Okay.
I was just going to say, if any of you asked what you could do, if you know of anybody that would be great. Him and I were talking yesterday, and he said, what's kind of your roadblock to a great candidate? And, they need to be ready to leave bedside. They need to be ready to be involved in regulation. And, Hemant kind of said, aren't there enough burned out nurses out there that would love to come work with us? So if you think of anybody. Yes.
Mm-hmm.
It's in person. It's not, your pool would open wildly if it could be a remote position. You give them a task and, that sort of thing.
Yeah, I'm truly believe, because I know people as well, but it's like, man, I can't do Austin, or if it was just a partial time or travel or whatever, so.
Easier said than done. So
Yes.
let's
Yeah,
kinda-
yeah.
Orientation is
tough. Yeah. A good point. Okay. Thank you. Yes, it is showtime, and I think we have some instructions. So we've completed everything on our agenda, but 9, I guess, point 2. Board development presentation on development and application of 22 Texas Administrative Code.
213.33.
Sorry, 213.33. Our.
Okay, what's going to happen with this agenda item, hopefully, if there's no technical difficulties, is I'm going to display the presentation on these slides while Brian here will stream the board through these cameras. So y'all need to get in a position to where y'all can see the screens.
So probably moving to chairs down there, but we have to be visible for Open Meetings Act. Yeah, okay. And I'm just telling them.
Us?
Yes, yeah.
Will be visible down there.
Mm-hmm.
Take our laptops with us?
Well, we're going to be seeing it up there. So it's not in our lab. Your presentation is, yeah, but we can take notes. Okay. Got it. Yes. Okay, yeah. Let's go ahead while we're getting moved and everything. Let's do 10 and then we'll be back. And right now it's 10. So 10:10. Start with 9.2. Dusty, thank you.
Thank you. I know that's boring, but I get a lot out of it myself, and hopefully y'all might learn something. This is going to be a walk, kind of from the Magna Carta to the disciplinary matrix, unfortunately. So y'all have to bear with me. The objectives, we're going to review the history and authority of the Board of Nursing regarding licensure discipline, more or less. We're going to review the genesis and the development of the disciplinary matrix, which for those of you who want to know how it's described in the Texas in the Texas Administrative Code, it's Figure 22 TAC 213.33B. It's named a figure because it's not words, it's actually a graph or a table, and we'll get to that. And we're going to explore the current use and the application of that matrix as best we can, because SOA and the board uses it in all of it, should use it because that's what the rule says in all of its decision making. Okay, let's start with the agency mission. The mission of the Texas Board of Nursing is to protect and promote welfare of the people of Texas by ensuring that each person holding a license as a nurse in the state of Texas is competent to practice safely. Remember y'all's mission statement as we go through this. Remember, and I know you know this, the board is defined exclusively by statutes. The statutes that create it, the statutes that control it. The first Nurse Practice Act was passed in 1909, and we had over a century of amendments to it. Every legislative session probably. I didn't go back that far. I'll save that for another time. And of course, the combination of the boards in 2004. That's called the enabling legislation, the Chapter 301, 303, 304 of the Texas Occupation Code, the Nurse Practice Act, the Nurse Peer Review Chapter, and the Nurse Licensure Compact. The board's enabling legislation defines the board, talks about its powers, and then of course you have to mix in everything else that affects the board. The Administrative Procedures Act, the Open Meetings Act, the Public Information Act, lots of government code provisions that not only define who you are, but control what you do. And here we are, after over 100 years. Look at these subject matter experts. Why is this important, right? Because the legislature can't control everything about an industry, because they would be locked up trying to figure out how to approve nursing schools, whether they meet the criteria, all this other stuff. They have to delegate basically to subject matter experts in a subject matter field to control and regulate that. And look at our subject matter experts. Look at what they've done. This is who you are. Your educators, your active practitioners, your consumers who have an interest in protecting the public. The fundamental authority that you have. You regulate nursing practice. You approve nursing education programs. You license qualified applicants. You investigate complaints, and you issue anything from corrective action to all discipline. And I want to thank right now the nurse consultants who have developed these slides that I'm using. Yeah, because thank you. These are interesting. When you get to mine, you'll know it when you see it. Okay. Okay. Now with this great power comes great responsibility. That's Spider-Man, okay? If you need a little more gravitas, how about Luke 12:48? To whom much is given, much will be required, okay? Let's talk about the rulemaking authority, because this is where you're really going to kind of, I want you to hone in on this. The Nurse Practice Act includes the authority for you to adopt rules. The rulemaking authority allows the board to implement and enforce the laws that are passed. It's power. The rulemaking allows you to detail guidelines, standards, procedures to address specific issues in your jurisdiction. What does that mean? What does rulemaking mean? It means that you pass laws, just like the legislature, that can be enforced as law, okay? Let me go back. Well, I wanted to go back. That's this way, right? Remember, you get to pass laws. Okay. The Nurse Practice Act, laws that you're created, they can be amended every 2 years. You have rulemaking, you interpret the NPA, you operationalize the NPA, you amend periodically through rulemaking, and they both have the force of law. The statutes and your rules. Now let's go to the origin of BON enforcement. Coincidentally, in 1909, Senate Bill 11 included this statement about your authority. The act to define and regulate the practice of professional nursing, create the Board of Nurse Examiners for the examination of nurses, prescribe their qualifications, provide the proper registration, and fix suitable penalties for the violation of this act. One of your fundamental, that's why we're getting to the disciplinary matrix. I just want to set the stage that it's always been core to the Board of Nursing. Now, what is the statute? The Nurse Practice Act lists the grounds for when you can take disciplinary action. A person is subject to a denial or disciplinary action for what? A violation of the NPA, fraud and deceit in procuring or attempting to procure a license, felony misdemeanor involving moral turpitude, conduct that results in revocation of probation, using a fraudulently obtained license, impersonating someone, aiding and abetting an unlicensed person in the unauthorized practice. These are statutorily listed reasons how you can take action, right? Let's continue with those. Discipline from another jurisdiction, intemperate use of alcohol or drugs, unprofessional conduct in the practice, adjudication of mental incompetency, lack of fitness, performing a terrible unauthorized examination, and failure to care adequately and conform to the minimum standards of nursing. Just another little history lesson. 452B13, the examination provision, was adopted a couple of sessions ago. It ruined all of our previously drafted policies and templates because they didn't put it at the end. They put it where number 14 used to be 13, one of our most commonly quoted statutes of conforming to minimum standards, got changed to 14. Little unintended consequence, I think. Okay. More of our beautiful slides from others. Enforcement, it's a big part of what we do. Receive complaints, investigate, ensure that there's due process, right? For everyone, it's part of what we were required to do. We have to give written notice. We have to give them an opportunity to respond. They're entitled to attorney representation. They have access to information. It's all outlined in our act. It should be a fair and just resolution. That's what due process is, okay? So, what type of discipline can we actually impose? That's defined by statute. We have the grounds for what you can hold them responsible for, and then you have your power over them on what kind of discipline can you impose. You can deny their application. You can issue them a warning. You can issue them a reprimand. You can put restrictions. It gives you some flexibility. You can put restrictions on their license. You can suspend their license. You can revoke their license. You can assess a fine. A lot of power for any one of those violations, right? You violate 1 through 14, you're subject to this type of power. You can make someone submit to care. You're statutorily authorized to require your licensee to submit to care as a condition of their renewal. You can make them do remedial ed. You can make them practice for a specific period of time under the direction of another nurse. The legislature's given you that power. You can make them perform public service. We haven't really done that.
No, we haven't.
No, but you can make them abstain from alcohol and drugs. And force them to submit to random drug screenings in order to assure that they're abstaining. You can probate any penalty, and you can impose other conditions on reinstatement. It's just vast, your power, right? Okay, so we know, thank you, Paul. You know that the level of sanctions conceptually is easier to, you don't have your license anymore. It's a graduated choice. And I think fundamentally in our hearts, we know that due process needs to be fair, right? It's a sense of fair. Well, this has always been the duty of the board, and staff has always worked hard to make sure that we have a fair result. It's been here as long as I've been here, since '98. And this is where it starts getting really weird for me, going way back. Okay. Wait, what happened? Let's go to the origins of the disciplinary matrix, because it didn't always exist. But you know what? It has always existed for y'all, the board members here. It's always been here for y'all. There was a point in time that it did not exist. It was just a case would come along, a case would come along. The thousands of cases would come through, and we would litigate them, settle them, approved by the board. It was it's what we did before y'all were here. It's what we do now, but there was no matrix. So, this is Gina's slide. She found that. It's probably some sort of a trademark infringement. But the Sunset Advisory Commission, in their 2006-2007 cycle, came up with a recommendation that we needed to adopt an enforcement matrix by rule. They had a bunch of pages. So you can go there to their website and go look at that report. I was talking to Tony about this. He's one of the old timers like me. He said that they were interested in us doing a matrix because of our routine, our uniformity, or what we told them. How do you do this? They met with us. How do you do your enforcement? How do you do this? Well, if it's minor, we do this. If it's serious, we revoke. It's this sort of continuous development of a protocol, and it was really a protocol that was here and here and here and voted on, and they wanted more. They said, well, You need to put this concept in rule. So if you want to go to their website and look at these old reports, fascinating. This was a serious sunset for the Board of Nursing. It had a lot of education associated with it, how we were going to do education. It had a lot of Dr. Hooper, you're a saint and wonderful. You did so much. The workforce commission stuff, trying to divide all the responsibilities between nursing and all those crazy. Anyway, one of the recommendations was you should require the board to have a matrix in rule. It will help them be consistent. It will be used. Don't use it. It won't be used as a one size. Nothing is a one size fits all. You need to take into account their history, their seriousness, their things like that whenever you impose. And nurses need to be ready to access this information so that they understand what's happening to them. Kathy, I was talking to Kathy about this. She said, we're the ones that told them that we were on the verge of, needing a matrix and doing it. And then I think they took that from us and made it like there was. Well, then the House Bill 2426 was the sunset bill of that session. It had a lot of things in it. But what it did was it added 301.4531. And a lot of times you can kind of look through our Nurse Practice Act and see, well, when are the new amendments coming in? Well, they add a number to them. They add the fourth digit. This comes after 453, which is of sanctions. To ensure that the severity of the sanction imposed is appropriate for the type of violation. You're going to have to look at, have that rule determine about multiple violations, seriousness of the violation, the threat of the violation to the public, any mitigating factors. And then, if they have a history, more than one, maybe you should consider being more severe. These are all, by the way, now that I'm thinking about it a little bit more, that's what we were telling them. That's what we were saying would probably be the way, a graduated view of the more violations you get, the history, the more serious you might, your penalty might be whenever you come back. And they created the statute that outlined this. Well, now, there's a little distinction here, right? The recommendation was an enforcement matrix in a rule. The statute called it a schedule of sanctions. So initially, in June of 2007, the board proposed amendments to 1333, which outlines schedule of sanctions. And it's basically what the statute said. But it included, you'll get more, be more serious if you have multiple. The board will look at, more serious look at history. Remedial ed is in our authority. Warning is in our authority. If we give you a warning, then might be able to put, it may include supervision, it may include drug screens, it may include, reprimand. If we give you a reprimand, it may include drug screens. If you get, we can impose conditions on reinstatement, sort of in rule. 233 has that now, but it was more like in the statutory format that you would think. That rule was effective October 2007. But we needed further response to the matrix concept. We had a very bright legal intern, Michael Bacon, who helped me and I think Joy sort of create something different, the matrix. a table, something that would hopefully accomplish and provide guidelines. In April of 2008, the board approved the matrix as a pilot. They wanted to analyze whether it was going to be, whether its use would be fair and could be applied in a fair and consistent manner. Would it do all these things? Would it include mitigating factors? These guidelines needed to be tested in the current decision-making and board precedent that was being used. In January 21, the board adopted the disciplinary matrix by rule. Kathy Lederhorn, you were there. Chris was there. I was there. Tony was there. Y'all weren't there. But y'all have inherited it, right? And that's why we're having this sort of, hopefully that's what you'll get from this board development. The history, its development, its adoption, and it went into the Texas Register as Figure 22 TAC Section 213-33B. And if you look at the rule right above it, A says appropriate sanctions. Now let's reflect on what the grounds are. Can y'all read that? What the grounds were for action? You know, this is from the statute: violation, deceit, conviction, failure to follow the minimum standards, etc. Okay. Remember your grounds for disciplinary action. Now, this is the tricky part. This is what I'm hoping. Here it is. There it is. The figure. All right, here we go. Figure 22 TAC 13. Let's see. I want to, yeah, there we go. There we go. All right. How can I get rid of that thing? Over here with the X? Just hit that X? Okay. All right, let's what I'd like to do now is I would like to explore the matrix with y'all. And this will be, I want this to be more informal, or not, because I want y'all to see how it's used as a tool. And you'd stop me, but I'll be reading, so you have to say, Dusty, stop. Okay? All right, so let's look at, remember, we revisited the grounds for disciplinary action. 301-452B1, a violation of 301, rule, blah, blah, blah. Well, let's see. How's the matrix developed? Oh, it has, is it a first tier, second tier? What does that mean? What does that mean? It means that the type of offense is more serious as you go down. The more serious the offense, the more you need to be in that matrix. If it's serious, maybe there's a sanction level. Maybe there's a room for flexibility in the sanction for that type of violation. Well, let's start with what was defined as a first-tier violation. Isolated failure to comply with a procedural rule, such as failure to renew within 6 months, failure to comply with a technical non-remedial requirement in a board order, such as failure to pay a fine, failure to timely complete your remedial ed. You have violated your board order. That is a 301-452B1 violation. What did you do? Oh, I didn't pay my fine. Well, what happens? Well, we're looking at sanction level 1, remedial ed, maybe more remedial ed with or without education. If the stipulations are prior, that are still outstanding, you have to comply with those and get a fine. Or you might get a warning or reprimand. May limit, because what if the technical violation might have been, one or two failure to, comply with your board order by getting a random drug screen or something. Well, we want to make sure that you, depending on how many technical violations, you might move into this category of level 2. What about tier? What if it's a second tier? What if it's a substantive requirement? Well, what do we mean? Well, embedded in the matrix normally are examples, right? Fraud or falsification. Substantive requirements are those stipulations in the board order designed to remediate, verify, monitor the competency. Normally they're the supervision stipulations, right, in your board order. They were there to make sure that you were competent. Your violation led to a stipulation. Then, sanction level 1 or 2, you could may be required to complete the original board order. You may be subject to a higher sanction or extension of the stipulations. Does anybody want to stop me here? Does anybody have an idea why it's like that? Do you see the wisdom of the matrix? Okay.
I wish I'd had this one.
What was that?
I wish I had seen this when I first came up.
Yes. And here's the third tier. Violation of a substantive probationary restriction required in a board order that had limited your setting or scope. For example, failure to submit to random drug screens, intentional submission of false or deceptive reports. That seems more serious. That's a B1 violation that seems a little bit more serious than failure to pay your fine within 60 days, right? And then you have this, you're probably looking at revocation at that point, right? That's pretty serious. I mean, false reports, positive drug screens, violation of your abstention stipulation. But we also want to make sure that when you're looking at a B1, you want to evaluate all, potential possibilities. You want to look at aggravating circumstances, right? Multiple offenses, continued failure to register for remedial class, recurrent failure to provide information required by your order, mitigation, right? You're in violation of your order, but you had unforeseen financial or health issues. You were not practicing during a stipulation period. Okay. How about y'all pick a violation that you want me to use the disciplinary matrix tool with? Anyone? Anyone?
Alcohol. Misappropriation.
Intemperate use? Intemperate use. Okay. I'm sorry, what? Misappropriation. That's unprofessional conduct. That's in our unprofessional conduct area. So it goes through all of them. Fraud and deceit in procuring. Look at that. I think that a failure to honestly and accurately provide information in your application, it could be as low as remedial ed, right? Or it could be denial or revocation because your lie was so patently associated with your incompetence to get a license. Let's see. Okay. Oh. We've had a lot of history regarding our actions on criminal conduct, right, in the past. So our disciplinary matrix sort of refers you to more focused analysis on what's appropriate remedy whenever you have a criminal conduct. We also have, do you remember, 301-4535 has to be taken into account because that's a mandatory revocation for those heinous, what they call the heinous felonies. Use of a nursing diploma or transcript that has been fraudulently purchased. It's sort of outdated now. That provision's sort of outdated now. Impersonating another person in the licensing examination require. There's only one sanction for violations like that, right? It wasn't very difficult to do that part of the matrix. All right, let's get to the intemperate use of alcohol that could endanger. First, let's look at what this asterisk means. I don't know, it's missing. Misuse of drug without a patient interaction. No patient harm or adverse patient effects. No previous history. No other aggravating circumstances. Warning with stipulations. Misuse of drug without patient interaction, no risk of patient harm. However, individual has previous history. Level 1, maybe back to TPAPing, back to peer assistance. Level 2, maybe, given the nature of the violations, revocation. Let's look at the aggravating and mitigating factors. Yeah.
It may be important to note, because somebody said alcohol, but when you have a drug violation, 9 times out of 10, that's going to also be a misappropriation violation. It's going to be a failure to document violation. It's going to have several violations looped into that, so you may want to discuss how those are dealt with.
Okay. It's subject to, Oh. Yes. Thank you. That asterisk on the top of intemperate use, you may be eligible for peer assistance. We won't, our encouragement of this could be a disease, these types of things, you want to make sure that you're in violation, but there may be alternative to discipline, I think, is what that asterisk represents. Yes, Carol?
So looking at that top one when it said with no patient harm, could that be a nurse that got pulled over for DUI or DWI? Because they're not in a clinical setting, but they got pulled over.
No. No, this more or less focuses like, they,
In the clinical setting?
well, they might have pulled some out of a drawer, went home, that kind of thing. I think Tony's identified that these are not just this ground for violation. You might have stolen a drug from a facility. That's an unprofessional conduct violation. That's B10. When you have these multiple violations, and you'll see them in the order, right? B1, B7, B10, the rule that applies. Recall that the sunset passed the law 301-4531, the schedule of sanctions, and in it, it described that the board should probably evaluate whether there's multiple violations, probably evaluate what is the worst, and probably seek within the schedule of sanctions, consider the higher penalty. So this matrix is then, sort of used in conjunction with the responsibility that you need to take into account maybe the worst of the violations and utilize these others as possibly being aggravating to the worst of the violation. But in all fairness, sometimes it's the singular event that, and often you can find in any analysis in the matrix, the appropriate remedy fits the right tier in all of them. This is what that's kind of I honestly believe it doesn't work out this way all the time, although I'm hard pressed to think of an exception. You can look at a case differently, whichever one of those provisions was violated. You can go to the tier and the sanction level of each one of those types of violations, and often if it's the same event, it fits. That is the beauty of the consistency, the fairness. It sort of makes sense that what you want to do fits all those categories, often fits all the boxes. Unprofessional conduct, it provides some comply with the board rules. Again, it's very similar to B1. Board order, board rules. Isolated violation, minor unethical conduct, remedial ed as the first type tier. Multiple, maybe isolated, you might, mishandling, of drugs, it might get you into a warning level where you might be required to. These tier and sanction levels were built on history. Were built on the types of violations that we see and had seen and do see. And we have, in 2010, it became our rule that we argue at SOA and that we apply, the investigators are trained on it in doing their case evaluations. The lawyers have to argue the matrix every time they go to SOA because the rule says SOA should apply the disciplinary matrix. You're going to argue the aggravating circumstances, the mitigating circumstances. You provide, this is also, I want to say, provides the respondent with a blueprint for how to, say it's not bad. I have a blueprint on how I could say I had all these things. I didn't do this. I didn't do that. Right? And gives them fairness, uniformity, consistency. I know now, at this point, I have probably exhausted your interest. So I think I've taken a big bite out of the disciplinary matrix. You think, John?
We cover the factors at the end of the matrix. The C factors.
The C factors. I didn't get to that point. Yeah. Okay. Do you think I should cover the C factors? John. Thanks for derailing my ending.
As Dusty defines the C factors, I just want to emphasize also the role of the consultant, the expert witness. They are there to demystify the matrix and educate the judge on, how the proposed order came about. So, they could give this presentation too.
Chris, I was wondering, do you ever wonder, as our board staff give expert testimony, that it's been a hot minute since board staff have been in a practicing nurse role? Not that that decreases your opinion at all, but I just wonder, has that ever come up?
So that's a great question. So the purpose of them being present as an expert witness is to speak to the matrix.
How do I close this up?
Not necessarily to speak as an expert in ICU. But I can tell you through experience that does come up, and it does, they may try to challenge, you as being an expert.
And I would also say, when we're testifying to the matrix.
That's enough. I don't know how to hide that.
The matrix applies to different.
How do I hide
So
that?
the professional conduct rules. Matrices.
How do I hide that? Make my thing bigger?
The standards matrix is related to the standards of practice. So most often our formal charges, whatever we're alleging, is going to boil down to something that's within a violation of our standards.
No, I want to hide this. I want to hide so that it makes this page bigger.
Specifically to, let's say, John and I had a case with ventilators that we just agonized over. So if we needed somebody to speak specifically about what's going on currently in ICU with a ventilator, we could get a nurse that could speak to that, and then my role would be just
Yes.
to how that fits as
Tim, those are different views.
Okay.
All right. The matrix, and then there's C factors. The 233 goes on. The board and SOA shall consider in conjunction with the disciplinary matrix in determining penalty, mitigation, aggravation, the multiple violations, etc. Now here is a list of those considerations that I think speak to, what do they speak to? Fairness, maybe? Fairness? Due process, maybe? Actual harm to patients, lack of truthfulness, all these, the things that were listed in 301.4531 to be considered. Any other matter that justice may require. I don't want to just read those off. I think it's enough for y'all to sort of see the level of attention that each violation gets at the board. Each order that y'all are presented to review gets this attention. Some things have been delegated to the executive director to enter on your behalf, to enforce some orders on your behalf, provided they fit within the matrix. That has been evaluated by the board, and that authority had been delegated. Normally, it's peer assistance, related to peer assistance and those types of results that have fit within the matrix. Okay. I've come to the end, but I'm ready for any questions.
Can I ask a question? I'm just looking at this and thinking of the Nightingale situation. It's different here, but I'm wondering if we could ever have a matrix to help us with Nightingale decisions, or if there could be a one about the potential for risk to harm a patient. Particularly, many of these have had no clinical in their program and no clinical practice.
That's a good question. And the answer is yes. It should be evaluated in the context of the matrix.
Because I know you're going through litigation with, or investigations with some of these individuals in this Nightingale thing. Because it's not in the disciplinary matrix, can they use that against the board? And so,
Well, I think I could address that later.
okay, never mind.
You'll hold it for questions. You're in charge of the mic.
Where in impersonating a nurse, and we hear, this pops up a lot in the news, and someone's claiming to be a nurse and purporting to be a nurse, but they're not licensed as a nurse. If they're not a licensee holder of the board, do we have jurisdiction, or is that a separate piece of statute that says you can't impersonate a nurse and it doesn't fall under the purview of the board?
It falls under the purview of the board as a separate piece of authority. It is a crime to do that. It says so in the Nurse Practice Act. It is it provides some authority for us to enjoin, if we so chose, to get a district court to order them to stop. Okay? It would be kind of a different process, but and we also have authority. The board has authority to be a vehicle to inform the public on matters, to keep the nurses and the public apprised of nursing issues. And we inform them of imposters. And we refer those people to the local law enforcement who have the jurisdiction over that person in their district to pursue the crime, which is which we don't do. We can't put you in jail.
So just anecdotally, since I've been on the board, I've seen several of those. Do the district attorneys typically pick those up, or are they like, yeah, do y'all know?
Well, obviously, there's a range of decisions associated with that type of behavior. You get law enforcement involved, they stop. Sometimes that's probably the best thing. They stop. If they don't, if they've hurt somebody, that's just put on top of the other items that they have been alleged to have done.
Right. I believe the imposter that comes to mind is Tony Stringfellow. She was a person in San Antonio who continued to impersonate a nurse, and she was ultimately convicted of a felony offense, impersonating a nurse. So but she did it multiple times. She got caught, she continued to do it. So they finally convicted her of it. But she did it after that too.
Some nurses have been arrested, some imposters have been arrested for that, and some have not. But most all of them stop when we get wind of them.
I have a question. So when an actual crime is committed, does it necessarily not, or does it go to like on the criminal side, like diversion of drugs? That's stealing. What happens with the actual act of stealing?
If it's pursued by law enforcement as a crime, then that is reported to us as a crime, potentially independently of the Nurse Practice Act being reported as that occurring in the practice of nursing. We get crimes that are reported and then open a case, yes. Sometimes there's these parallel tracks where the facility catches the nurse perpetrator taking drugs, reports them to the board under their license, and reports them to law enforcement. And law enforcement may pursue criminal charges, which are normally with drugs and taking them, or felony level charges, which the board has jurisdiction to review on that type, and particularly if it's in the practice of nursing.
Would there be an instance where it was reported to us, but there was no law enforcement involved, but it rose, in y'all's opinion, to the level of a criminal act that y'all would then, in turn, report it to the police?
Rarely. We look at we do realize, it depends, right? We do realize that these individuals are often in the throes of a disease. And we are worried about the competency as a nurse. And we look at the seriousness of the action, the number of times, the patient harm, all the things that the board is authorized to take action on and evaluate, and that decision's made against the license.
For the drugs, that's such as the nurses that have done the unauthorized breast exams or whatever, that rises to an assault. But if it just came to the board, would we then, or does that not?
We don't have the jurisdiction to take action as if it was a crime.
No, you don't take action to let somebody know. I understand that.
You have to notify the patient, so the patient then reports it, right, civilly. They've done that. I've also been in a situation where we report it as well. And then back to the diversion, it depends on the facility. In our healthcare system, we have a strict policy through pharmacy where they report to DPS, parallel with nursing reports to the board. So there's checks and balances.
All right.
Thank you very much. And especially all the history and the foundation for it. I think that is great as well. So thank you for doing that. So can we get copies of these slides?
Yes. Yes.
Okay. Like emailed to us? I just think there's some facts there, and I do some speaking at different times, and some of those I might want to pull in some of that history information. So, yeah, thanks a lot. And I know it's a lot of work for you guys and Dusty, and thank you for your time to do that, and board members. And so if we don't have any other business in any way, then it's 11, I think it was 11:12, and we're adjourned. Thank you.
Now that we've adjourned, I just